Good morning and welcome to the Public Service Commission of South Carolina. We are in docket number 2024-34-E. This docket concerns the application Dominion Energy South Carolina Incorporated seeking an increase in electric rates and related adjustments to its electric rate schedules, tariffs, and terms and conditions used with its customers of all types, whether residential, commercial, or industrial, within its service territory of operation. We are now at a stage where there are witnesses being presented by the Office of Regulatory Staff. But before we do, I would like to clear up one thing while it's on my mind. If you go back to one of the public hearings, Mr. Juarez was asked and said that he was going to submit a bill. It's exhibit number 7. It's my understanding that ORS reached out, talked to him, and he decided not to submit that exhibit. Is that correct, Mr. Mustian, or one of you?
Chair Powers, after that public hearing, our consumer services staff touched base with Mr. Juarez, and he informed them that he was not willing to provide his bill as a late filed exhibit.
Okay, so exhibit 7 will be a blank. Thank you very much. Ms. Rainey, you may proceed.
Thank you. Chair Powers, member of the commission, ORS calls to the stand Courtney Radley, Anthony Brazzino, and Brandon Bickley. Good morning. I'll start with you, Ms. Radley.
Well, they need to be sworn
Oh.
first.
Raise your right hand, please. Do you swear affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
I do.
I'll start with you now, Ms. Radley. Would you please state your name for the record?
My name is Courtney Radley.
And by whom are you employed and in what capacity?
I am employed by the state of South Carolina as an audit manager for the Office of Regulatory Staff.
Did you prepare or cause to be prepared 31 pages of direct testimony on June 5th in this docket?
Yes, I did.
Do you have any changes or corrections to your pre-filed direct testimony?
Yes, I do. On page 1 of my testimony, I state that I am employed as a senior auditor for ORS. Subsequent to the filing of my direct testimony, I was promoted to audit manager. Additionally, on page 11, line 22 of my direct testimony, the reference to the ORS request number should be 12-07, not 5-017.
Thank you. And if I were to ask you the questions posed in your pre-filed direct testimony, would your answers be the same?
Yes, as corrected from the stand.
Chair Powers, I move that Ms. Radley's pre-filed direct testimony, as corrected from the stand, be entered into the record as if given orally from the stand.
The pre-filed direct testimony of Ms. Radley, as corrected from the stand, will be submitted into evidence as if given orally from the stand.
Thank you. And Ms. Radley, did you pre-file with your direct testimony 9 exhibits marked as Exhibit CDR1 through CDR9?
Yes, I did.
Do you have any changes or edits to your exhibits?
No, I do not.
Mr. Chair, I ask that Ms. Radley's 9 exhibits, Exhibits CDR1 through CDR9, be entered, marked, and identified, and entered into the record as the next hearing exhibit.
The exhibits CDR 1 through 9 will be marked identification and entered into the record as exhibit number 39.
Okay. Ms. Radley, did you pre-file or cause to be pre-file 18 pages of surrebuttal testimony in this docket?
Yes, I did.
Do you have any changes or corrections to your surrebuttal testimony?
No, I do not.
And if I were to ask you the same questions today as those posed in your pre-filed direct testimony, surrebuttal testimony, would your answers be the same?
Yes, they would.
Chair Powers, I move that Ms. Radley's surrebuttal testimony be entered into the record as if given orally from the stand.
The surrebuttal testimony of Ms. Radley will be entered into the record as evidence as if given orally from the stand.
And Ms. Radley, did your surrebuttal testimony include one exhibit marked as surrebuttal exhibit CDR1?
Yes.
Do you have any changes or corrections to that exhibit?
No, I do not.
Chair Powers, I ask that Ms. Radley's surrebuttal exhibit CDR1 be marked for identification and entered into the record as the next hearing exhibit.
The surrebuttal testimony of Ms. Radley exhibit consisting of CDR1 will be entered into the record for identification and marked as exhibit number 40.
Now to you, Mr. Brazino. Please state your name for the record.
My name is Anthony D. Berzino.
By whom are you employed and in what capacity?
I'm employed by the South Carolina Office of Regulatory Staff as the Senior Audit Manager.
Did you prepare or cause to be prepared confidential and redacted versions of your pre-filed direct testimony on June 5th?
Yes, I did.
Do you have any corrections or changes to your pre-filed direct testimony?
No, I do not.
And if I were to ask you the same questions as those posing your pre-filed direct testimony, would your answers be the same?
Yes, they would.
Chair Powers, I move that Mr. Brazino's confidential and redacted pre-filed direct testimony be entered into the record as if given orally from the stand, and that his confidential version remain under seal.
The pre-filed direct testimony of Mr. Anthony Brazino, both confidential and public version, will be entered into the record and submitted to evidence as if given orally from the stand. The confidential part shall remain confidential.
Thank you. And Mr. Brazino, did you pre-file with your direct testimony one exhibit marked as Exhibit ADB1?
Yes, I did.
Do you have any changes or corrections to that exhibit?
No, I do not.
Chair Powers, I move that Mr. Brazino's Exhibit ADB1 be marked for identification and entered in the record as the next hearing exhibit.
The Exhibit ADB-1 of Mr. Anthony Brazino will be entered into the record as Exhibit 41.
And Mr. Brazino, did you prepare or cause to be prepared 11 pages of surrebuttal testimony for this docket?
Yes, I did.
Do you have any changes and corrections to your surrebuttal testimony?
No, I do not.
And if I were to ask you the same questions as those posed in your pre-filed surrebuttal testimony, would your answers be the same?
Yes, they would.
Chair Powers, I move that Mr. Brazino's pre-filed surrebuttal testimony be entered into the record as if given orally from the stand.
The pre-filed surrebuttal testimony of Mr. Anthony Brazino will be entered into the record as if given orally from the stand.
Okay. Now, Mr. Bickley, would you please state your name for the record?
Brandon Sinclair Bickley.
And by whom are you employed and in what capacity?
I'm employed by the South Carolina Office of Regulatory Staff as the manager in the Energy Operations Division.
Did you prepare or cause to be prepared 69 pages of direct testimony that were pre-filed in both confidential and redacted forms on June 5th, 2024?
Yes.
Do you have any changes or corrections to your pre-filed testimony?
No, I do not.
And if I were to ask you the same questions as those posed in your pre-filed direct testimony, would your answers be the same?
Yes, they would.
Chair Powers, I will move that Mr. Bickley's confidential and redacted versions of his pre-filed direct testimony be entered into the record as if given orally from the stand, and that his confidential version remain under seal.
The confidential and public version of the pre-filed direct testimony of Brandon Bickley will be entered into the evidence or into the record as if given orally from the stand. The confidential portions of that shall remain confidential.
And Mr. Bickley, did you include in your pre-filed direct testimony 9 exhibits marked as exhibits BSB1 through BSB9, which includes both confidential and redacted versions of BSB9?
Yes.
Do you have any changes, corrections to those exhibits?
No, I do not.
Chair Powers, I ask that Mr. Bickley's exhibits BSB1 through BSB9 be entered into the record. BSB1 through BSB9, the public version, be entered into the record as a composite exhibit, and that the confidential versions remain under seal.
The exhibits BSB 1 through 9 of Brandon Bickley shall be entered into the record marked for identification, and I think it's Exhibit 9 only is a confidential version, and it shall remain confidential.
Correct, thank you. And Mr. Bickley, did you prepare or cause to be prepared 17 pages of sure rebuttal testimony in this proceeding?
Yes.
Do you have any changes or corrections to your sure rebuttal testimony?
No, I do not.
And if I were to ask you the same questions as those posed in your pre-filed sure rebuttal testimony, would your answers be the same?
Yes, they would.
Chair Powers, I ask that Mr. Bickley's pre-filed sure rebuttal testimony be entered into the record as if given orally from the stand.
The pre-filed rebuttal testimony of Brandon Bickley shall be entered into the record as if given orally from the stand.
And Mr. Bickley, did your sure rebuttal testimony include one exhibit marked as sure rebuttal exhibit BSB1?
Yes.
Do you have any changes or corrections to that exhibit?
No, I do not.
Chair Powers, I ask that Mr. Bickley's sure rebuttal exhibit BSB1 be marked for identification and entered into the record as the next hearing exhibit.
The rebuttal exhibit BSB-1 of Brandon Bickley is marked for identification and entered into the record as Exhibit 42.
Okay. Chair Powers, this panel is,
43. I'm sorry, 43.
okay, thank you.
His prior was 42, the 1 through 9, and this would be 43, my fault.
Okay. Chair Powers, this panel is available for commissioner questions. Thank you.
Thank you. Any commissioner questions? Commissioner C. Williams.
Thank you, Chair Powers. Good morning. Thank you all for being here and for all the work that went into your review of this application. And I'm going to start with Ms. Radley. Congratulations. And I have one question. I appreciate the parties kind of coming up with a consensus regarding the kind of ceiling for the legal fees, and wondered what went into that. Was it that's a new recommendation. I think it's at the ceiling being $525. I think we just started to see that, and so wanted to understand a little bit about what ORS considered in coming up with that ceiling. Is it something that will change, or is it something we're going to where the inflation may have an impact on it? Just give us a little bit of background.
ORS has noticed that rate case expenses and the level of rate case expenses and customers paying for those expenses has been a topic of discussion across the nation. And so as just a way to help mitigate customers being required to pay for rate case expenses that the company elects to incur, ORS is recommending a $525 cap per hour for legal fees. That's consistent with our recommendations in the two most recent rate cases, the 2023 70G Dominion Gas rate case and the recent DEC rate case.
And how did you arrive at that number?
I was not part of the discussions to arrive at that number.
Would you imagine it'll change over time based on inflation and other factors?
I'm sure that ORS will continue to discuss the $525 amount specifically. I cannot speculate on what ORS's position will be in a future case.
Thank you. Mr. Bickley. This has to do with settlement agreement and just clarifying for the record what's included and what's not. And some of it has come up before, but regarding the idea of streamlining, developing standards to streamline the information exchange for the discovery process, is that something that is included in the stipulation number 34? Let's see. No, it was 30 that says, That's probably not appropriate. Let me just back up and say, the idea of streamlining information exchange for the discovery process, is that something that, where does that stand in the process?
So, Commissioner, if you look at item number 47 on page 16 of the settlement agreement, that paragraph references the discovery concerns and issues that ORS
Okay.
had during the process, and that ORS is open and amendable to working with the company for future rate cases and other proceedings to establish, guidelines and good communication going forward.
Thank you. Clear as a bell now. Is there any industry standard for tracking materials and supplies? And does that industry standard look at dates purchased and kind of movement turnover of a particular item?
So I'm actually glad you asked that question, Commissioner. If you would turn with me in my direct testimony, to page 65, and if you'll indulge me, this is to clarify my direct testimony. ORS has entered a settlement agreement with the company that all the parties agree to or do not object, in which ORS fully supports. Now, to clarify your question specifically, if you look at lines 3 through 7 on my direct testimony, that refers. I'm sorry?
What page number again?
Page 65.
Okay. 3 through 7? The question and the answer?
Yes, ma'am.
Okay.
That refers to 18 CFR Part 101 of the FERC Uniform System of Accounts. And what that specific language refers to is cycle counts, and it refers to a specific 2-year time frame. So the methodology behind ORS's review is to look at materials and essentially to start with materials and supplies that are 2 years and older, and then to double that and look at 4 years and older. Once you get to the 4 years and older period, at that point in time, you typically would have done approximately 2 cycle counts of your M&S. And with that in mind, if you have material that's 4 years or older, then ORS will take that information and go another level deeper. Then we will look at materials and supplies that are under, say, like a hold status or maybe a blocked status.
Okay.
And to clarify, a hold status typically is a material or a supply or a piece of equipment that cannot be used for one reason or another. We use the same methodology in the most recent DEC rate case, if you recall my testimony there. We also use the same methodology in the most recent DEP rate case in 2022 to 2023 approximately. So similar methodology. But we take that the M&S material that is 4 years or older, and again, we go one level deeper, and we look at what is in a hold status. And then we review those items that are in a hold status. What is the specific reason? Why is it in a hold status? Is it within the company's control or is it not? And if you'll indulge me, I would like to point to the nuclear M&S material, which hasn't really been discussed much this week. So under the nuclear material that we reviewed, there were 3 item listings that were 4 years or older listed under a hold, or as the company referred to, a blocked status. Do not use, essentially. Of those 3 items, one was under a Part 21 designation, which so Part 21, just to be very simple, Part 21 designation means there's some problem, some issue that has to be addressed, and the majority of the time that's outside of the company's control. Not all the time, but typically. And I personally had to deal with Part 21 issues in the past. So that piece of material we put to the side because due to circumstances that's outside of the control. The other 2 items under the nuclear side dealt with solenoid valves. And those solenoid valves were listed under a block status. And I will actually go so that I read to you exactly. On page 64, so one page over in my testimony, according to the company, and this is on line 10, those solenoid valves are block stock due to expired shelf life, and even though the solenoid valves are potentially usable, the company has not used them. So those items are under a hold or a blocked status. They cannot be used. Maybe they can be used, but the company has not. So it was ORS's recommendation that since they haven't been used, they're in a block status, they are 4 years or older, is it fair and reasonable for customers to pay a return on those items? So that led to our nuclear recommendation, or nuclear M&S recommendation, to remove those items from rate base. Similarly, we applied the same methodology to the non-nuclear M&S material. Now, what ORS identified with the non-nuclear ORS or M&S material, once we asked for the dates of material that are 4 years or older, the company was not able to provide that information during the time that we were conducting our review for direct testimony. The company transferred program software and data from PeopleSoft to SAP in I believe it was January 1, 2021, subject to check. So since that information was not able to be supplied to ORS, we could not determine accurately what materials and supplies 4 years or older were in a hold status or a block status. Without that information, I cannot corroborate it, I cannot verify it. And ORS prides itself in using, solid data, factual information to support our positions. Because that information was not available, I could not complete that part of my review. We had a lot of discovery we sent to the company on that matter. If I recall, 8 questions, 75 subparts to be exact.
Say that again.
We submitted 8 discovery questions with approximately 75 subparts, so a lot of questions. We attempted rigorously to identify what happened and why. Would their information be available? Would it not? But the information was not available. We even had a MS Teams conversation with the company, just really to get to the roots of the problem. So to summarize that, the data was not available. I could not verify what information was in a hold or block status or a do not use status of 4 years or greater. And since I could not corroborate that, I could not reasonably make a recommendation to allow a return on that material for customers to pay for. So that's what led to the recommendation for the non-nuclear material. I hope that clarifies for you.
Absolutely, and it's good education. Now that you've given me that much education, just out of curiosity, what statuses are there beyond hold and block, if that's not too intense a question?
No, ma'am, it's not. And the company would be better to address their specific categories. One thing I'd like to point out is Dominion Energy South Carolina's categories are different than that of DEP and DEC. They are different than the categories that I utilized when I worked for the Department of the Navy, when I worked for the Department of Defense, when I worked for the Department of Energy, so on and so forth. Most entities will have their own categories and their own internal procedures. But generally speaking, Commissioner, you will have equipment that is ready for use, on the shelf, accessible, and then at times you will run into issues where you have material that is not available for use. So, on the nuclear side of things, Dominion Energy South Carolina stated that if a material can't be used, it enters a block status, right? So can't use that. To give you another example, DEP and DEC will have specific hold statuses, and some of that information specifics is confidential, but they have varying degrees of a hold status, whether it's something that requires engineering to do something or a third party to do something. But generally speaking, you have broad categories of I can use this material or I can't use this material.
Okay. That makes sense. I have one more question for you. In previous rate cases, unrecovered plant balances were included in rate base. Can you explain why ORS is taking a different position in this case?
So I'd actually disagree with you, Commissioner.
Okay.
In the recent-ish DEP rate case, if you recall, 2022-2023, there was a Roxborough wastewater treatment facility that was early retired. The company retired it early. And ORS using similar methodology, made a similar recommendation to exclude that from rate base. And to be clear, that means that the company cannot earn a return on the asset. They can earn return on the costs, but not also a return on the asset. And in that particular example, there were also decommissioning costs on top of the regular costs and a few other things, and we took no issue with that. Apart from the decommissioning costs couldn't be speculative. But again, that's one recent example. Another example in the recent DEC rate case, one of my colleagues, Mr. Hyatt, if you recall his testimony, he discussed hydro units that DEC had sold prior to the end of their useful life. ORS used similar methodology and took the same approach there. And then if you'll indulge me so I can get to the correct page in my testimony, because I give several examples. One moment, please. So on page 34 of my direct testimony, starting on line 18, and if you go from line 18 all the way through page 35, line 15, I actually give multiple examples where this commission has disallowed rate-based treatment for early retired assets. So I give several examples in my testimony there. I also give several examples from different utilities around the U.S. where they have disallowed rate-based treatment.
Thank you. I appreciate the disagreement and the facts behind it.
Absolutely, you're welcome.
Mr. Brazino, I have one question for you, and you might have heard it before if you were listening, and it has to do with the settlement agreement as it relates to the restricted stock units as benefits, and just wanted to, from your perspective, clarify what the settlement agreement allowed in that regard.
The settlement agreement allowed recovery of the restricted stock units.
At 100% or 50/50?
Yes, ma'am.
Okay.
100% recovery.
Thank you very much. No further questions.
Yes, ma'am.
Commissioner Caston.
Thank you. Mr. Bickley, I think I followed all of that. I mean, you certainly have a grasp of it. I just want to make sure I understood it. Relative to, and I think it was Mr. Kassam yesterday talking about it, and as far as the settlement goes, you know, there's an agreement, so it doesn't matter right now. But thinking in terms of those, I think the way you described it, those critical items that may have long lead times, because, you know, on a personal level, you know, where I was before, we had some of that too. You know, some old switch gear from the mill that was an odd voltage, old cast iron pipe with an odd OD outside the diameter, you know, that were critical items, and that, man, if this went down and we couldn't get it back on service pretty quickly, bad things were going to happen. So in terms of resilience, in all the process you defined and discussed, is that something that ORS recognizes, assuming the company can prove that point, that there are critical items with long lead times that you might not need it for 10 years, but when you need it, you need it?
Oh, absolutely. And I'm very glad you brought that up, Commissioner, because that allows me to fully answer Commissioner Williams' question, to sort of convey all the information. And believe me, I personally understand that. When I worked for the Navy, I can tell you without going into too much detail, some of those Los Angeles class submarines are using 80s tech or 90s tech. So in 2010, when a young engineer is trying to figure out how this submarine is functioning, and some of this technology is 20 or 30 years old, it's a challenge. But I do understand, and ORS does understand, you have critical spares, you have critical components, you have vital safety systems that require specific materials and supplies that have to go through a rigorous M&S process to be used. I've been a part of that in my career. I understand that, and ORS is aware of that. And that does play a role in our recommendations. To that point, that's why ORS goes several layers deep, right? We go from the 2 years to the 4 years. Then I look at the hold material. Then I look at the reasoning behind that hold material. that Part 21 designation for the nuclear M&S is a very good example where we thoroughly reviewed that and said, okay, that's out of the company's control. We're going to move that to the side. A critical spare or a critical component would also fall under a similar circumstance like that. And to be clear, Commissioner, my direct testimony and my rebuttal testimony doesn't say that this material is useless or that this material has no value. That's not the point. Really the point is on the non-nuclear side. The information was not available for ORS to go those few layers deep. Now, after the filing of my direct testimony, and in full transparency, the company in their rebuttal provided an updated discovery response on the Wednesday, forgive me, I don't remember the date, but the Wednesday that rebuttal was filed. And along with the rebuttal testimony came the updated discovery response saying, okay, we hear you, ORS. We've done some work. And here is, subject to check, Commissioner, I don't recall exactly, approximately $40 to $45 million of the 85 that was in rate base. The company was able to say this material is 4 years or older. And I don't recall exactly what was said about the remainder of the material. But again, that was provided on the day of rebuttal. ORS had 5 business days to write rebuttal. The company's response included an Excel sheet with 30,000 plus lines of data. I'm a human being. I can't review 30,000 lines of data in 5 business days. And just to be fully transparent with you, Commissioner, my whole family was recovering from hand, foot, and mouth disease that my awesome 15-month-old brought home. So that was a lot of fun. Anyway, short version, couldn't review that to corroborate the data. I would have liked to. Really would have liked to. Really would like that information earlier too, but would have liked to have reviewed that information. But there just wasn't time to do that before rebuttal. So, sort of again, just to summarize, the information wasn't available, Commissioner, but we do take critical spares, critical components, things of that nature into account. We do.
Good, thank you. And life happens, doesn't it?
It sure does.
And I appreciate that. I kind of thought that's what you said, but that just absolutely cleared it up and clarified it for me. And relative to the 5 days and not having a lot of time to do that, I'm assuming that's part of the settlement item also, as far as that discovery and helping ameliorate that.
Well, and I'll also add, in my direct testimony, I also recommended that the company review and update its processes, and at the next rate proceeding, ORS obviously is more than happy to review the data that the company presents at a future proceeding for that particular proceeding.
Okay, thank you. That's very helpful. Appreciate it. Thank you.
Yes, sir.
Any further commissioner questions? Panel, thank you very much. You may step down. I think that's it as far as the live witnesses. Mr. Mustian, I don't know who will handle this, but there are 5 witnesses that their testimony is going to be submitted by verification. We can go through that now if it's okay, and get the record complete.
Thank you. I would like to note yesterday, ORS filed verification forms for Mr. Collin, Mr. Hyatt, Mr. Watkins, and Mr. Seaman Wynn. We plan to file the verification form for Mr. Thompson tomorrow. He's unavailable today.
I'm sorry, could you speak up on that last part?
We're unavailable to file the verification for Mr. Thompson. He's unavailable today, so we plan to file that tomorrow.
All right. Okay, but you have Mr. Shane.
Yes, we pre-filed his as well. So you want to start with Mr. Hyatt? Or
Any way you want to
okay,
do it.
let's start with Mr. Collin. Mr. Lane Collin pre-filed 26 pages of direct testimony. And his testimony included 3 exhibits, LK-1 through LK-3.
All right, the testimony, the pre-filed direct testimony of Lane Collin will be submitted in evidence as if given orally from the stand. The exhibits LK-1 through 3 shall be marked, and that would be Exhibit 44.
And Mr. Collin pre-filed 10 pages of rebuttal testimony. And with his pre-filed rebuttal testimony, he included 2 exhibits, rebuttal exhibits LK-1 and rebuttal exhibit LK-2.
All right, the rebuttal testimony, pre-filed rebuttal testimony of Lane Collin will be submitted into evidence as if given orally from the stand. The rebuttal exhibits LK-1 and 2 marked for identification and entered into the record as exhibit number 45.
Thank you. And Mr. Hyatt next. Mr. Hyatt pre-filed 19 pages of direct testimony, which included both confidential and redacted versions. And he also pre-filed, let's do this, Exhibit 1 through 4. Exhibits 2, 3, and 4 are confidential, and we would ask that they remain under seal.
All right, the pre-filed direct testimony of Donald Shane Hyatt should be submitted into evidence as if given orally from the stand. The exhibits DSH 1 through 4 will be marked as exhibit 46, and the exhibits DSH 2, 3, and 4 confidential versions shall remain confidential.
Okay, and Mr. Hyatt also pre-filed 5 pages of rebuttal testimony.
All right, the rebuttal testimony of Donald Shane Hyatt will be consistent of 5 pages, will be submitted to evidence as if given orally from the stand.
Mr. Watkins next.
All right.
Mr. Watkins pre-filed 47 pages of corrected direct testimony, and his pre-filed direct testimony included 6 exhibits marked as exhibits GAW1 through GAW6.
The pre-filed direct testimony of Glenn Watkins, consistent of 45 pages, will be submitted to evidence as if given orally from the stand. The exhibits GAW1 through 6 will be marked for identification, entered into the record as exhibit 46. 47.
And Mr. Watkins also pre-filed 17 pages of rebuttal testimony, which included 1 exhibit marked as rebuttal exhibit GAW-1.
The rebuttal testimony of witness Glenn Watkins will be submitted into the evidence as if given orally from the stand. The rebuttal exhibit GAW1 will be marked for identification, entered into the record as exhibit 48.
And next we'll do Mr. Seaman Wynn. Mr. Seaman Wynn pre-filed 11 pages of corrected direct testimony, and his direct testimony included 2 exhibits marked as exhibits MSH-1 and MSH-2.
All right. What I'm looking at is that there was an MSH1 and then corrected MSH1.
Yes, I believe that was corrected. Let me see.
Is that correct?
I know the testimony was his exhibit. Just a second. Verify. It was corrected.
Okay, so but there's still a number 2 on there too. Exhibit 2. Okay, number 2 would be the corrected version. All right, I got it. All right. The corrected pre-file direct testimony of Mr. Seaman Wynn will be submitted into evidence as if given orally from the stand. The two exhibits, MSH1 and the corrected version of MSH1, which is Exhibit 2, will be entered into evidence, marked for ID as placed into the record as number 49.
Chair Powers, can you hold on a second? We want to verify that it was the corrected direct versus surrebuttal. So just a second.
Yes, corrected direct. I apologize.
Yes, it's corrected direct. Okay. So the last witness is Mr. Thompson. Mr. Thompson pre-filed 6 pages of direct testimony.
I think before that, we need to put in the surrebuttal of Mr. Seaman Wynn.
Okay. Well, Mr. Seaman Wynn pre-filed 6 pages of surrebuttal testimony and 2 exhibits marked as surrebuttal exhibit MSH1 through MSH2.
All right. The pre-file surrebuttal testimony of Mr. Seaman Wynn will be submitted into evidence as is given orally from the stand. The surrebuttal exhibits MSH1 and 2 are marked for identification and entered the record as Exhibit 50.
Okay. Now we go to Mr. Thompson.
That's
He
fine.
pre-filed 6 pages of direct testimony.
All right. The pre-file direct testimony of Amari Thompson will be submitted to evidence as if given orally from the stand.
And Mr. Thompson also pre-filed 4 pages of surrebuttal testimony.
The pre-file surrebuttal testimony consisting of 4 pages of Mr. Amari Thompson will be entered into the record as if given orally from the stand.
Thank you. And I would note again that we plan to file Mr. Thompson's verification form tomorrow.
That's acceptable.
This concludes ORS's case in this matter. Thank
All
you.
right. Is there anything else from any other parties?
No, sir, we have nothing.
Okay. First, this is my first big case as chairman, and I do appreciate the professionalism and courtesies you've all shown, and I guess the word is patience. I've been tested for patience, and it turns out I'm negative. So I'm doing my best, but I do appreciate all of it. I appreciate the hard work that's been put into this case. And I really want to thank the commissioners here who you can obviously see just didn't say, okay, you have an agreement. They've worked hard, they've researched, they've done their job, and I'm very, very proud of this panel for the work they've done, as well as the staff. There's so much that people do not know goes on behind the scenes, both for us and for y'all, all of you. And it's hard work, but it's good work, and it's important work. And I sincerely thank you from the bottom of my heart. I would ask that the lawyers please meet with our counsel as to proposed orders and whatever else she wants to bring up. And I think she's going to.
Mr. Chair, before you close, I would like to be recognized.
Oh, I'm sorry, I did not see you, Vice Chair.
That's fine. But
You have the floor.
Thank you, Mr. Chair. Mr. Chair, I echo your comments regarding how well you led us during this proceeding. Definitely couldn't tell it was your first time, so thank you for your leadership there. I would be remiss if I did not make a few observations, especially considering that at this point in time, I'm the most senior commissioner on the dais, believe it or not. The youngest and yet the most senior. It's interesting how life works out. According to the American Psychological Association, trauma is an emotional response to a terrible event like an accident, crime, natural disaster, emotional abuse, neglect, war, experiencing violence, death, or many other traumatic events that I'm sure we've all, if we haven't experienced directly, know someone who has experienced such an event. And going further, the National Institute of Health says trauma results when you either experience that traumatic event firsthand or secondhand. And I would submit to you that the failure of VC Summer Units 2 and 3 was a traumatic event for the state of South Carolina, for the Commission, for the Office of Regulatory Staff, for SCENG, and the legacy employees that are still at Dominion. It was very traumatic. It caused a loss of trust. It caused a lot of chaos. And if I'm being honest with myself, I probably wouldn't be sitting here talking to you all today, but for that trauma. And what I'm impressed by through this case is the resiliency demonstrated not only by the Commission or the Office of Regulatory Staff, but the folks that came from what was SCENG and now Dominion, and how they represented themselves in this case. In my short tenure, even being the most senior, this was the most transparent and authentic case that I think I've heard in my time here at the Commission. To the extent that one of the witnesses even shared with us that while they would have wanted to go through 30,000 lines, a family of 5 with hand and mouth disease prevented such. I think at times, just speaking for myself, we can forget that we are human. And there are reasons for why we can and why we cannot do some things. And the positions taken by the parties in this case, including the Office of Regulatory Staff, the Consumer Advocate, even SACE and CCL, and the energy users, and even Frank Knapp, say a lot to me about the company's case and their willingness to concede. Fellow commissioners, you note that not a single party cross-examined a witness during this case. We asked all the questions. And as a lawyer by trade, education, and training, that's remarkable. Even with the office or the consumer advocate not being a signatory. There was not a single question raised by a party. What do you take from that? And that's rhetorical, of course. What does that mean? That not a single party, not the energy users, and we know, I'm sure we should know, that Attorney Elliott loves using the cordless mic, the lavalier, and addressing the commission, but not even Attorney Elliott asked a single question. Not even the consumer advocate charged with representing the residential ratepayers, low income, senior citizens, the vulnerable populations, if you will. Not even the Office of Regulatory Staff that represents the public interest. Not even SACE and CCL. And I know, you know, like I know, that they don't mind asking some questions when they believe it's appropriate. And so I appreciate what the commissioners have done here in asking our questions and what the staff has done in preparing us for this case that ultimately resulted in the settlement that we've heard. And based on that, based on the testimony that I heard about the agreement reached on the time of use rates and the agreement reached on investments in the grid and how shareholders are, even though they didn't feel that they had to based on the law, or that they didn't feel entitled to some of those expenses, but wanting to do their fair share, if you will, to aid and assist in the burden of increasing rates, offered a one-time bill credit to ratepayers and are willing to pay for some equipment that they, again, believe that they were entitled to recover the expense for said equipment. Based on the entire settlement agreement, Mr. Chair, and understanding our traditional procedures and protocols, I would be remiss and I would feel a bit guilty if I didn't offer a motion to accept this settlement agreement as it has been presented, based on the facts and evidence presented during the course of this hearing. Again, I understand that we like to go back and dot our I's and cross our T's and make sure we feel comfortable with everything that we've heard and read and reviewed. But quite frankly, I feel as if we've done such a thorough job doing that since this application was filed. For me, there's no need for me to do that based on what I've read, what I've heard, and also what I did not hear. And so I offer that motion for the commission's consideration. And I welcome any questions from my colleagues.
Mr. Chairman,
Chair Bellis.
I appreciate the comments of Commissioner Williams. I join in a lot of them. However, I move that we table the motion.
There's been asked to table the motion.
Not debatable. You just have to take a vote.
All in favor?
Aye.
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 All opposed?
No.
I vote aye, the ayes have it.
I would like,
Commissioner
Yes,
Caston.
I never could hit a curveball, never could. But like Commissioner Belser, I wish I could say ditto to what he said. There were two things I simply wanted to say. One is I'm neither the oldest or the youngest. I'm the middle child. I just want to make sure that was clear. And the other thing is, in my brief experience here, I have been very impressed with everyone that's come before us. You know, not just the professionalism, but, you know, if somebody asked me all these questions, I probably just wouldn't respond as nicely as y'all do a lot of times. And I appreciate that. I really do, because you have to, sometimes you just have to tolerate the question and think, what did he just ask? And sometimes I maybe think I see it in the eyes. But I say all that for this reason. Just similar to what Commissioner Jay Williams said, I've always been impressed with the folks that come before us and how you handle yourself. And I hope when it's all said and done, and I'm no longer sitting here, you'll still think that same thing. So that's all I had to say. And if you're going to vote tomorrow, we'll do that. I'll leave that up to the chair. Thank y'all.
Thank you, Commissioner Caston, and I appreciate everyone's remarks. The Vice Chair particularly bringing up the fact that Dominion, coming into South Carolina, stepped into quite a position. Mr. Sam, it makes me think, if I ever run into an old girlfriend, I can say, oh, that's pre-you. But you were here for the long run. I don't think you get to say that. You just have to do your job. And we appreciate everything you do. If there's nothing further, then this hearing is now adjourned. Thank you very much.